Yes. Oh, okay. But there's one motion, na? There's one motion. Yeah, first motion.
Lordship, I beg to mention item number 10. I need to consult from the department. So the matter will be released on 23rd next week.
Item 10.
Item 10.
Next week.
Next week, 23rd.
They're not. The Government Advocate, Mr. Im Timson. Yes.
The Lordship actually have gone through the affidavit and I will not be filing a reply.
You will not be filing a reply.
Yes, to this.
Okay. What do you want?
For more
No.
instruction.
For-
Instruction.
You have already filed your
Yeah, I
affidavit.
have already filed and sent the copy to the petitioners.
So what further instruction?
Because it involves a lot of figures and this and that. So unless I take certain instruction, I may not be in a
Okay.
comfortable position.
Okay. What did I say? Learned Additional Advocate General, Mr. Im Timson, praised for 2 weeks.
Next week, 23rd July.
Okay. Praised for listing the matter on 23/7 as he wishes to get some more instructions from the respondents. So, the learned counsel for the petitioner, Mr. Jansar, is present and has no objections. List on 23/7 as brief. Yes.
Please, Lordship. Lordship, I beg to mention item number 4, Lordship. On behalf of Unish Khan, Lordship.
Item number?
4, Lordship.
Yes.
Here, Lordship, the council is having some health difficulties, so if this matter may be fixed after 3 weeks.
You're mentioning for the petitioner?
Lordship.
Okay.
May I please, Your Lordship? I am appearing for respondent number 1, Your Lordship.
Respondent 1.
Yes, Your Lordship. On the last date also, Your Lordship, they have mentioned and taken some time, Your Lordship. So kindly a fixed date may be given so that on that day.
Who's appearing here? M. Solo.
M. Solo and Unish Khan, Lordship.
So what's your problem?
He is having some health difficulties, so.
Health problems.
Yes, Lordship.
So we can give a consensus date according to your conveniences.
Next month, Your Lordship.
Next month.
Yes.
Learned Counsel, Mr. L. Pom makes a mention on behalf of the counsel for the petitioner to list the matter when? On
August.
13/8, on 13/8 as 13/8/2026 as the council has some health issues today. So the learned counsel, Mr. Sarnasar, appearing for the respondent number 1, has no objections. List on such and such as prayed for. Yes.
Obliged, Lordship.
Mr. Lordship, Lordship, I beg to mention item number 5. Lordship, we are going to file our reply.
Okay.
So kindly 2 weeks time.
Learned counsel, Ms. Taitulo, appearing for the petitioner, praised for 3 weeks.
2 weeks.
2 weeks time to file a reply to the affidavit filed by the respondents. Prayers allowed list after 2 weeks. Yes. Learned counsel, Ms. Sarnasar, is present for the respondents.
There's
The interim order issued earlier shall continue till the next date of listing. Yes.
Lordship, I have some for one letter IA. The connected the main case has been listed today, but the IA has not been listed today. So I may be allowed to move the matter today. The IA is for withdrawal of 50% of the award. Since there is urgency.
Let it come up tomorrow. It's okay. Let it come up tomorrow. You give the mention memo, list it tomorrow. Yes. Yes.
Please, Ladyship, I beg to mention item number 11. I'm for respondent number 5 and 6.
5 and 6.
Yes, can you grant 4 weeks time to obtain instruction? He's under process for compliance.
Any objection? Learned counsel for the petitioner, Ms. Grace Namgi is present. Mr. K. Angami appearing for the respondent number 5 and 6. Praised for 3 weeks time to receive 4 weeks. 4 weeks to receive instructions and to file the compliance affidavit. So, list after 4 weeks as prayed for. Yes. Or maybe we should I think we should call the result case first because they're waiting for a long time. Okay, yes.
May I please, Lordship?
After
Lordship,
they
I beg
mention.
to mention item 12 and 13. Lordship,
and
in
13.
compliance to the earlier order dated 9/6/26, we'll be filing our compliance affidavit tomorrow. So if the matter could be listed after a week.
Regarding service of notice.
Yes,
Complaints
Lordship. Yes,
affidavit,
Lordship.
Learned counsel for the appellant submits that he would like to file an compliance affidavit regarding service of notice upon the respondent's number.
Lordship,
You're
this-
appearing for?
two-
No, they are already appearing.
Lordship, I'm for respond number 1, item number 12.
One, okay, so that means 2 and 3
Yes, Lordship.
for respondents number 2 and 3. Praise for listing the matter after a week. Stop. List after a week is prayed for. Learned counsel, Mr. Sir and such is present for respondent number 1. In item 12, okay, only in item 12. Yes. Okay. In item 13, none appears, no? No, 1 to 3 is represented in item 13.
Your Worship, in 13, we have already filed our objection.
For 1 to 3.
Yes.
1, 2, and 3.
Yes, for
So service would be for
services.
in item 13.
I beg your pardon, Lordship.
Yes.
Only item 12 will be taking
Okay,
up.
that is only in item 12.
Yes, sir.
Then in item 13,
We'll be taking up the matter, Your Worship.
okay. Don't say anything in item 13, no? Only in item 12. Yes,
Lordship, I also beg to mention item 20. Lordship, item 20, notice upon respondent 5 and 6 is still awaited. So if the matter could be listed after 3 weeks.
Learned counsel, Mr. Sergeant Search for the appellant submits that the service of notice on respondent number 5 and 6 is still awaited. So accordingly list the matter after 3 weeks, awaiting service report of respondent number 5 and 6. So Mr. Nongsa appears for
Respondent 1, 2, and 3.
number 1, 2, and 3.
Some leadership, we have filed our objection today.
Yes.
Lordship, similar prayer for item 21 and 22. Lordship, in these two matters, notice upon respondent number 3 have returned unserved. So if the matter could be listed after 3 weeks so that we can take fresh steps.
In both 21 and 22,
Yes, Lordship.
Learned counsel for the appellant, Mr. Saransa, submits that the notice on respondent number 3 has returned back unserved and accordingly he prays for 3 weeks' time to take fresh steps. Then in item 22, you say, in addition to that, Mr. Nongsa appears for respondent number 1 and 2.
1 and 2.
Yes. This after
3 weeks.
3 weeks. Yes.
Obliged, Lordship.
Please, Your Lordship, let me mention item number 24, hearing.
Yes.
Lordship, let the matter be fixed on 10 August.
10 August. 10 August is okay?
Okay, Lordship.
No objection. Due to consent of the parties, list the matter on 10/8/2026 for hearing.
Lordship, interim order. may be
The interim order passed earlier shall continue till the next date.
My please, Lordship. First, I'd like to mention item number 6, ma'am. Lordship, here the leading counsel for it Ahmad is indisposed today, ma'am. So I believe this matter can come up after 3 weeks, ma'am. Consensus prayer.
Who's the counsel?
For it Ahmad, for the petitioner.
Okay, learned counsel Mr. Medavero for the petitioner submits that the arguing counsel is what?
For it Ahmad. Is indisposed today, ma'am.
Is such and such who's indisposed today and accordingly prays for listing the matter
After 3 weeks, ma'am.
after 3 weeks. So, learned counsel for the respondent number 2. Such your name, give your name for the respondent number 2 is present and has no objections. What about state?
Sir Tipapom, I've taken the consent from him also as well.
List after 3 weeks is prayed for. Yes.
Not utilized, Lordship. Lordship, I would like to mention item number 25, ma'am. Lordship, on the consensus prayer, if this matter can come up on 3rd of August, ma'am.
3rd August.
Objection.
The prayer of the parties list the matter on 3rd August 2026 for hearing. Yes.
Not utilized, Lordship.
Yeah, please, Your Lordship. I'd like to mention item number 8. Your Lordship, here,
We're yet to file our affidavit in opposition. Some time may be given, Your Lordship.
On behalf of respondent number 2.
Respondent number 2.
Respondent 2. Learned Counsel, Ms. Such and Such appearing on behalf of respondent number 2. Praise for
Your Lordship, if the matter may be listed on 17th of August.
Praise for listing the matter on 17/8/2026 in order to enable the respondent number 2 to file their affidavit in opposition. So, Learned Counsel, Mr. Such and Such, who's for the petitioner? Mr. Such and Such is present for the petitioner, as well as Ms. S. Mary for the state respondents. So, list on such and such, the date. Yes. That will be for admission hearing.
Yes, Your Lordship.
Yes, admission hearing.
Your Lordship, I also beg to mention item number 17 and 18. We are yet to receive instruction, Your Lordship. 3 weeks' time may be granted.
You're mentioning on behalf of?
Cindy Younger.
Okay. Learned Counsel, Ms. Such and Such, mentioning on behalf of Mr. Santiago, special PP for the respondent number 1 to 4, submits that she's yet to get the instructions and accordingly prays for
3 weeks'
3
time.
weeks' time. So, list after 3 weeks. So, Learned Counsel for the petitioner, Ms. Grace Namki is present. So, yes, 3 weeks.
Your Lordship, similar prayer in item 23.
23 after 3 weeks.
Yes, Your Lordship.
Yes, with the consent of the parties, list after 3 weeks for hearing.
Much obliged.
Isol bench matter, bail application 49 of 2026.
May I please your lordship?
Yes.
My lord, this is an application under section 483 of BNSS for enlargement of the accused on bail as she was summoned and thereafter arrested on 5th 8 2024 by the Excise and Narcotics team, Lunglei, in connection with SC number so-and-so arising out of excise case number so-and-so registered under section 21B of the ND-NPS Act. My lord, my primary grounds is basically on the grounds of arrest, and section 48 has not been complied, my lord. But before coming to that point, my lord, in this particular case, there are two accused, my lord.
Okay.
The prosecution case in brief is that on 5th 8 2024 at about 10:50 a.m., excise personnel searched the residence of co-accused, that is Silan Mwansanga, at Sanmari, Lunglei, and allegedly recovered 185.71 grams of suspected heroin concealed inside 2 air purifiers kept in the kitchen and the bedroom. The applicant was not arrested. The instant applicant was not arrested in the place of seizure. My lord, the record itself states that she was brought from her residence and was arrested later at 4 p.m. at the Excise and Narcotics office.
When were you arrested?
My lord,
Date of arrest? Date of arrest?
date of arrest is 5th 8 2024
24.
at 4 p.m. at the office of the Excise and Narcotics.
And trial has started?
Yes, my lord, the trial has started. In fact, it is at the stage of WA.
Okay, okay.
But my lord,
And
since this is the case of Lunglei, I have annexed in my petition in page number 50, my lord. That is the notification dated ISOL 4th November 2025, my lord.
okay, okay, I remember this case.
Yes, my lord. So this is the first time approaching to the...
Learned PP, I think we can let him go because this is also not commercial quantity.
Yes.
It is intermediate quantity. And plus, she has been in custody since 5/8/2024.
Yes, my lord. 1 year, 8 months.
Even without going into the other grounds.
That is the discretion of the court, my lord. As for the submission that Lunglei district judge has been the additional the special court has been promoted to the district judge. I have given one citation, my lord, one order of this honorable court. Bail application 27 of 2026. Yesterday I have,
Okay, yes, yes. Order dated 24/4.
yes, my lord. In this case, my lord, it was sent to the back to the district judge. The similar case, my lord, even the present petitioner has come for the first time for bail. And in this
Okay.
bail application also, my lord.
Okay, okay. The special judge was not approached.
Yes, my lord. This is the first time he has filed an application for bail.
Okay. So now has someone come in Longlai? Has any judge presiding officer been
Yes, my
posted?
lord. Your lordship will see from this order at para 7.
Para 7.
On perusal of the aforesaid notification, it appears that all the judicial officers in grade 1 of the Mizoram Judicial Service were designated as Judge Special Court NDPS Act. As such, it appears that the Session Judge Lungde is a designated court to take up matters under the NDPS Act. So in this case also, it was sent back to the
Okay.
district judge.
In that case, we can pass a similar order.
Yes, my lord.
Because you had approached this court on the ground that the presiding officer was transferred, isn't it?
Correct, my lord.
So now that this notification is there and designating all the judicial officers, grade 1 officers as special court, then there should be no problem. Yes. Okay. Heard Learned Counsel, Mr. Ricky Lalrod Fella for the petitioner. So I've also heard Miss Linda M. from Bowell, Learned PP for the state of Mizoram. So, para the instant bail application under section 43 of the BNSS has been preferred by the petitioner, bringing for enlargement on bail in connection with the case number SC 75 of 2024 arising out of excise case number 304/2024
308, my lord.
308/2024 slash LLI registered under section 21B of the NDPS Act. So, the case of the petitioner is that the applicant was first arrested on 5/8/2024 and the charge sheet has already been submitted and the trial had commenced. However, and the case is now under trial in the court of the additional district and session judge Longlai district. However, the learned presiding judge has been promoted and transferred out, isn't it? Transferred out from Longlai, rendering the NDPS court
No, my lord, not transferred, elevated, promoted, my lord.
has been
In the same
promoted.
district, my lord.
Okay. Has been promoted as district and session judge, rendering the NDPS court vacant with no successor appointed till date. And as such, the trial has not progressed and no further proceedings have been taken up, thereby violating the principles of speedy trial. Stop. Para. Under such circumstances, the learned counsel submits that the bail application has been filed before this court as the presiding officer of the NDPS court Longlai has been promoted and there is no presiding officer at present. So we will not go into the other grounds, okay? At this stage, The learned PP has produced a copy of the order dated 24/4/2026, passed in bail application 27 of 2026 by a coordinate bench of this court, wherein a similar case was taken up by the court, and at paragraph 7 of the said order, it is reflected that as per notification number A, capital A, A 12035/1/2008-LJE dated 16/12/2010, all the judicial officers in grade 1 of the Mizoram Judicial Service have been designated as Judge Special Court NDNPS Act 1985. So, as such, the Session Judge Longlai is also a designated court to take up matters under the NDPS Act 1985. Under such circumstances, the said bail application was transferred to the Court of Learned Session Judge Longlai for adjudication. Stop. Learned PP therefore submits that this case, being similarly situated, may also be transferred to the Court of Learned Session Judge Longlai. Stop. Para. This court has considered the submission of the learned PP and has also produced the order dated 24/4/2026, passed in bail application 27/2026. So, in view of the fact that the present application is also similarly circumstanced, and in view of the fact that the Session Judge Longlai is a designated court to take up matters under the NDPS Act 1985, the instant application is transferred to the Court of Learned Session Judge Longlai. The Session Judge Longlai is directed to take up the instant bail application 49 of 2026 filed by the petitioner and dispose the same as expeditiously as possible. Stop. The registry shall communicate this order to the Learned Session Judge Longlai. With the above directions, the instant bail application stands disposed.
Obliged.
Obliged, my lord.
For motion item number 1.
Your Lordship, liberty may be given to me to file a fresh petition.
Yes. Actually, there's a question of maintainability, isn't it?
Yes. Actually, it was filed in the form of appeal, whereas the prayer is under 227 of the Constitution of India.
The format is wrong actually.
Yes.
You withdraw it, refile.
Liberty may be given to me.
Yes. The appellant, Mr. K.L. Gupta, is present in person. Stop. The Learned Advocate General, Mr. Im Tim Song, appears for the respondents number 1 and 2 and has raised the issue of maintainability as the instant petition has been filed, as the instant appeal has been filed under the wrong provision of law. So, the petitioner prays that he may be allowed to withdraw the application with liberty to file afresh. So, accordingly, the appeal is disposed of on withdrawal with liberty to the petitioner to file afresh. Yes.
For motion from the supplementary courses, item number 26.
May please, Your Lordship. Lordship is taking up item number 26. Submit.
Yes, motion.
Motion, my lord. In fact, I have filed this IA 152 of 2026 with a limited prayer for stay of the contempt proceeding till a disposal of the writ appeal or the stay petition that has been filed in connection with the writ appeal. My lord, here, my lord, by the order, judgment and order dated 21/2026, in WPC number 94 of 2022, I have annexed, my lord, as annexure A.
Annexure A.
A. Direction has been given to pay a certain amount of money. My lord, I'm sorry, my lord. This is the my lord, judgment is my lord in the contempt case, my lord. Annexure A, my lord. Contempt case at page 11.
WP 94.
WP 94. Operative part, your lordship, may come to page 37, paragraph 55.
37. Yes.
The said amount of rupees so and so only shall be paid by the respondent number 1 to 3 NHIDCL to the petitioner within 3 months from the date of this order after making payment to the petitioner so and so within a so and so manner. My lord, these having not been paid, my lord, instant contempt proceeding has been instituted. In the meantime, we have also, my lord, assailed this judgment in a writ appeal.
Writ appeal admitted.
A writ appeal, my lord, there was a delay, my lord. Lordship will find annexure A of the, my lord, IA at page 12.
Yes.
IA number 134 of 2026.
Okay.
There's a delay, so therefore, my lord, the notice has been issued. My lord, my limited prayer, my lord, that this
Petitioner.
Lordship, I'm for the petitioner in the contempt petition.
Your prayer is to keep it pending.
Lordship, will only the proceeding be kept in abeyance.
Till the appeal is disposed.
Lordship.
Okay, any objection?
Your Lordship, my respectful submission is that along with the appeal, 2 IAs have been filed. Now, for the condonation of delay, IA has not been heard and there is no stay order. So, considering at this juncture, I pray that this IA may be kept pending until a stay order is obtained in the appeal, Lordship.
Well, this has been settled by Katana of decision by the Supreme Court, my lord.
The thing is, see, if the judgment is reversed, if the single bench judgment is reversed, then problems will be created. So it's always better to keep it pending. Okay.
Lordship.
The instant application has been filed by the respondent number who?
1, 2, 3.
Respondent number 1 to 3 with a prayer for keeping the proceedings of the connected COP civil number 30 of 2026 in abeyance till the disposal of the writ appeal number 28 of 2026, which is pending before the division bench of this court. Stop. Para, heard, Learned Senior Counsel, Mr.
I'm psychiatric.
Assisted by such and such.
Muajamil.
Okay, assisted by Muajam. Stop. Para. The submission of the Learned Senior Counsel is that the that against the order dated judgment and order dated 21/2026 passed in WPC
94 of 2022.
WPC 94 of 2025, the applicant herein has preferred writ appeal, which is registered as writ appeal number 28 of 2026. So, the writ appeal was accompanied by an IA Civil 134 of 2026 seeking condonation of delay of 120 days in filing the connected writ appeal. Stop. By order dated 24/6/2026, in IA Civil 134 of 2026, the division bench has issued notice, and the same is listed on 12/8/2026. Stop. Learned Senior Counsel therefore prays that the connected COP Civil number 30 of 2026 may be kept pending till the writ appeal, as well as IA 134/2026 and IA 135/2026 are disposed of, as the applicants have taken good grounds and there is every likelihood of succeeding in both the IAs as well as the writ appeal. So, para. Learned Counsel, Ms. Such and Such is present for the petitioner in COP Civil number 30 of 2026, and she has objected to the prayer made by the applicants herein on the ground that there is no stay order in as far as the judgment and order dated 21/2026 passed in WPC 94 of 2022 is concerned, and that the IA for IA number
134 for delay, 135 for stay.
26 has not been allowed or disposed of. Just say that the IA such and such for condonation of delay, praying for condonation of delay, has not been allowed by the division bench, and accordingly she prays that this petition may be kept pending till the IA is disposed of. Isn't it? That's your para. This court has considered the submissions of the Learned Senior Counsel as well as the Learned Counsel for the petitioner. It is the view of this court that in the event the delay is condoned and the writ appeal is allowed, irreparable loss would be caused to the petitioner hearing, and therefore it is appropriate that the instant connected COP Civil number 30 of 2026 be kept pending till the disposal of the writ appeal number 48
28 of 2026.
2026. So
Proceeding is kept in abeyance.
yes.
Okay.
Accordingly, the IA number, the instant IA is allowed, and the proceedings in COP Civil number 30 of 2026 shall be kept in abeyance till the disposal of the writ appeal number such and such.
Obliged.
Prohibition item number 2.
My pleasure, Your Lordship. Your Lordship, on the earlier question, my learned friend Mr. Pakin Richavo has sought time to file his wakalan nama on behalf of respondent number 2. However, his name is not been reflected in the cause
Not
list, so I think
reflected,
he has not yet filed the wakalan nama.
He appeared on the last day.
Yes, on the last
When?
two occasions.
Date?
22nd 6.
On the last two occasions, he has paid for time to file his wakalan nama. That is on 1st of June and 22nd of June. The state has also not filed any affidavit.
Are you filing any affidavit?
Lordship, I'm yet to receive instruction.
If they are not filing any affidavit, then the
You
lordship,
can-
let this matter may be fixed for hearing.
Lord.
Yes, we can do that. Learned Counsel, Mr. Sims are present for the petitioner. Stop. On 1/6/2026, Learned Counsel, Mr. Pakin Chapu had appeared for the respondent number 2 and submitted that and prayed for 3 weeks' time to obtain instructions and to file his Vaklatama. Stop. On 22/6/2026, another 3 weeks' time was sought to file Vaklatnama on behalf of respondent number 2. Stop. Today, when the matter is called, none appears for the respondent number 2, and there is also no Vaklatnama on record. So, Learned PP, Mr. Victor Zimomi is present for the state respondents. So, what about records or at least case diary?
Lordship, I will produce the updated case diary.
List the matter for admission hearing, okay? For admission hearing, when? On 13th August 2026, so on which date the learned PP shall obtain the updated case diary.
No. Okay, right.
May I please, Lordship? Lordship, this matter, I pray that this matter may be listed for hearing after 4 weeks, Lordship.
Notices complete
All parties are represented, Madam.
and records, trial court records. It's done. With the consent of the parties, list the matter for hearing when?
After 4 weeks.
After 4 weeks, as the parties are represented, or as the parties are all represented, and the trial court reports have also been received. List after 4 weeks.
Much obliged.
Item number 7.
May I please, Lordship, the matter is listed today for admission hearing as per order dated 14/6, Lordship.
Such a thick file.
I will try to conclude within one hour. Lordship, will not take much time. Only part 1 will be relevant. Only part 1 will be relevant. So I will be referring only to part 1.
Part 1.
Yeah, in both parts, but only part 1.
You're ready?
Yes. My please, Lordship.
Yes.
The present petition is filed under Section 482 CRPC and Section 528 BMSS, read with Article 226 and 227 of the Constitution of India, praying for, amongst other, quashing of criminal proceedings in respect of the petitioner in connection with ML case, ML money laundering, case number 1 of 2024, pending before the Special Court PMLA. Now, Your Lordship, the petitioner is praying for quashment on the ground that the proceeding against the petitioner in connection with ML case number 1 of 2024 amounts to clear abuse of the process of law because not only it is contrary to the provision of PMLA 2002, but it is also against the law laid down by the Honorable Appeals Court in BJ Madanlal Chaudhary. I will be taking Your Lordship to the division. Now the relevant facts, Your Lordship. The petitioner is a private limited company incorporated under the Companies Act of 2013 and is engaged in the business as reseller agent for international gift card by providing services to international website to enable the Indian customer to recharge their e-wallet and also to purchase gift card from such international websites. Now, I will take Your Lordship straight to the case of the prosecution. Page 38, part 1. I'll be referring to only. I will try to be as quick as possible. Page 38, Lordship has got it? This is the prosecution complaint. Complainant is the respondent. It is filed before the special court, PMLA, Dimapur. And the case number is recorded as PMLA SC number 01 of 2024, Lordship. But here, let me clarify one thing. It is page number 36. Before the special judge, special court, it is registered as MLC number 1 of 2024. Am I clear, Lordship? Yes. So, this is the prosecution complaint filed by the respondent as complainant. May I take Your Lordship to page 49? Page 49. Now, in the prosecution complaint, I am serial number 85. The petitioner is named as accused 85. Accused number 85.
Serial number 85.
And Your Lordship, accused number 86 to 89, from serial number 86 to 89, they are directors and ex-directors, Lordship. They are also named as accused as per section 70 of the PMLA, because as director or ex-director, they are deemed to be guilty. So that is why they are also being named as accused. Accused 86 to 89. Now, next, may I take Your Lordship to page 74. Lordship has got it?
74.
74. So this is the in bold after the column. Complaint filed under section 44 and 45 of prevention of PMLA, read with section 70 of PMLA for commission of offence of money laundering as defined under section 3, punishable under section 4 of the PMLA. Now section 4 provides that the offence is triable by special court, section 44. And section 45 provides that the offence to be cognizable and non-bailable. And section 70, it relates to offence by companies. And section 3 of the PMLA, it defines the offence of money laundering, and section 4 is the penal provision. Now, may I take Your Lordship to page 75?
Okay.
Next, page 25. In the middle, FIR in bold. Lordship has got it?
Yes.
I may be permitted to read this FIR. Now, altogether, Your Lordship, 3 FIR has been filed. Now, this first FIR is dated 8/10/2021. This filed before the Cybercrime Police Station, Kohima, Nagaland. Now, that the Cybercrime Police Station, Kohima, Nagaland, registered FIR by crime such and such for offence committed under Section 420, 120B of the IPC, read with Section 66D of the IT Act against HPZ token. Lordship may kindly note this, HPZ. Section 66D of Information Technology Act, Lordship, it provides for punishment for cheating by personation by using computer resources. That's the thing, because these are app-based. So the FIR was registered against HPZ token. This FIR discloses that HPZ token was an app-based token which promised users of large gains against investment by investing in mining machines for Bitcoin and other cryptocurrencies. That the offence under Section 120B and 420 of IPC 1860 are scheduled offence under Part 1 of Para 1 in terms of Section 2(1)(i) of PMLI. Therefore, since a prima facie case for an offence of money laundering under Section 3 of PMLA, punishable under Section 4, appeared to be made out, investigation under PMLA was initiated by Dimapur Subdivisional Office of the Director of Enforcement by recording brief facts of the case under an ECIR bearing number such and such against HPZ token and others. So the predicate offence is the offence alleged to have been committed by HPZ token, Your Lordship, and against which FIR has been registered. So in short, HPZ token, the predicate offence. May I continue? During the course of investigation under PMLA, several evidences documents were collected and statement of several individuals were also recorded under section such and such. That in this case, the modus operandi adopted by the fraudster was first to first lure the victims to invest in the money in the pretext of doubling their investment through the app HPZ token. The scam was started in June 2021 and subsequently the fraudster stopped the payment to the investors and the website becomes inaccessible. The investors were assured that their invested money was being used to buy various mining machines by which cryptocurrencies were being mined and they were receiving or to receive gains against sale of such cryptocurrencies. Investigation revealed larger criminal conspiracies to cheat gullible people and found involvement of various related entities in similar apps or websites in receiving funds from public in pretext of unregistered gaming, betting, loan, etc. apps website. Now, this is the first FIR. The second FIR is registered by CID Police Station Ulubari, Gauhati, Your Lordship. This second FIR is also against HPZ token. Your Lordship, I kindly come to fifth line. 1, 2, 3, 4, 5. In bold it is written. Fifth line. Second FIR is also against HPZ token. Now, page 77.
This is dated 21/9/2021.
Yes. And page 77 is the third FIR. This is registered by CBI Delhi. This is dated 8/6/2022 and this also is against HPZ token, 8 line from top in bold. Lordship has got it?
MSHPZ, yes.
Yes. 8 line from top. May I take your Lordship to page 78 now? The para 4 in bold. This is
Page?
page 78. Next page in bold, para 4. This brief summary of cause of action. That is on the cause of action for investigation under PMLA. That is which gives jurisdiction to the respondent to investigate. I'll just take your lordship to the relevant portion, fifth line from the bottom. Since section, lordship has got it, since section 420 and 120B of IPC are the schedule offense under the PMLA, because HPC, against HPC token, the FIR complaint that was under 120.14. So, since 420B and 420 and 120B IPC is schedule offense under PMLA, investigation was initiated under PMLA against the accused person after recording brief facts of schedule offense in the ECIR. So, this is the cause of action, which gave jurisdiction to the respondent to investigate. 5. Brief facts of offense. 5.1. HPC token was an app-based token which promised users of large gain against investment by investing in mining machines for Bitcoin and other cryptocurrencies. The modus operandi of the fraudster was to first lure the victim to invest in the company in the practice of doubling their investment through the app HPC coin. The scam was started in June 2021, and by August 2022, the fraudster have stopped the payment and the website is not accessible now. Now, next page, may I take your lordship to 5.3, page 79, in bold. After that illustration, figure general modus operandi. Lordship has got it? Page 17.
5.3.
5.3. Now, during the course of investigation under PMLA, it is revealed that the victims investor of the HPC token are based across India. Banks account and payout accounts are opened in name of dummy persons. Wave of accounts and companies are created for rotation or layering of funds. Various payout accounts are opened in different fintech companies or API. The company's entities are incorporated just prior to commencement of the crime, that is, mainly prior to April 2001 and in FY 2020. The companies involved have prima facie dummy directors, and some cases they have already resigned. Though the web of companies and individuals, through the web of companies and individuals and app-based payment gateway, fintech companies, funds are rotated, transferred in multiple layers, and finally to individuals and related beneficiaries. In some instances, proceeds are transferred to virtual currencies or assets for laundering the money. Now, 5.4, next page. Investigation of fund flow, proceeds of crime. The chart is given. I'll take your lordship to the chart. Now, fourth line from the bottom of that para. Thus, prima facie. Lordship has got it? Primarily, it was found that Lilian Techno Cap Private Limited and Singo Technologies Private Limited were involved in the operating and collecting money for investor in the name of HPC token. Now, may I take your lordship to page 84. This is a figure 2 bottom. I have typed out a clear copy. Also, this is the flow chart of flow of proceeds of crime. The proceeds of crime from the predicate offense, that is HPG token. In the flow chart of proceeds of crime, lordship, petitioner company is not mentioned.
Petitioner company is Jyotisha
Jyotisha.
Technology.
Is not mentioned.
Okay.
Now, may I continue? Now, your lordship, though petitioner's company is not mentioned in the flow chart of process of crime, or as having received any proceeds of crime from the predicate offense, that is in short HPG token. The reason for naming petitioner company as one of the accused in the prosecution complaint as accused number 85 is mentioned in the brief summary of evidence to prove the charge, and which is page 224. From here I'll be jumping. Page 224. Lordship has forwarded.
Yes.
220. Bottom 10 is the
Brief summary of
brief summary of evidence to prove. Every word counts here. Brief summary of evidence to prove the involvement of the properties, that is the proceeds of crime, in money laundering and specific role of the accused in commission of offense of money laundering. And your lordship, this brief summary of evidence is based on the materials collected during investigation by the respondent and from the statement recorded.
This is all part of the complaint.
The part of the complaint.
Part of the complaint.
This is all part of. This is not my document. Whatever I am relying on is on their documents only. Now, how the petitioner company is involved? May I take your lordship to page 273. Lordship has got it. Serial number 85. Left column. MS Jyotisha Technology. This is the petitioner company. Married. The investigation revealed that the website used by the merchant, such that is the petitioner, is www.astropay.com, which was offering prepaid card facility and can be used in all betting and gambling websites.
Which is offering prepaid card facility.
The website also provided facility of cryptocurrencies. It was found that the merchant, that is a petitioner, used PayU Payment Private Limited platform for e-commerce line of business, but misusing Salt and Key. Here they have explained Salt and Key is used for encrypting and decrypting, while a Salt is used together with the hashing to make it even more secure. These are all technical, your lordship, but they have explained it, though I can't understand. As traffic are being routed from betting and adult site. During the transacting months, Chinese traffic was seen along with other international countries on the website such and such Extropay. Next page. It was found that top referring website for the deals into gaming, sports betting was another referring website, onlyfan.com, which is an adult site. It was noticed that the company, the petitioner, declared business in collection agency service and financial transaction, processing and clearinghouse services in GST, which does not match the transaction and line of business registered with AU, thereby confirming that the transaction going through the merchant were not as per the line of business. Therefore, the said company was indulged in parking and routing ill-gotten money to hide its source, and hence it was directly assisted and associated in money laundering as defined under provision of PMLA. As revealed during investigation, accused person is beneficiary of proceeds of crime. Accused person has not only received the proceeds of crime and also came in possession with such proceeds of crime. In the instance case, the accused person have knowingly acquired, possessed, transferred, layered, and used the said proceeds of crime obtained or devised by commission of scheduled offense in such a manner as if it was untainted money, and therefore guilty of offense of money laundering as per provision of section 3, read with section 70 of PMLA, and therefore liable to be punished under section 4 of PMLA. I'll be taking your lordship to the provision. Now 86 is a director. 86. He is the director of MS such and such and is getting monthly salary of this. He was recommended by Mr. Such and such. He used to send OTP for banking transaction and other company related documents through WhatsApp and email such as and controlling such. Now next paragraph. Hence he has knowingly assisted the petitioner in generating proceeds of crime and money laundering through various gaming, betting, adult website and cheated the gullible public and is liable to be prosecuted under PMLA. Now here, Your Lordship, my submission is this. This gaming, betting and adult website, that is the allegation, and through which I have received proceeds of crime. The predicate offense against which complaint FIR is filed before the cybercrime police, Your Lordship, it is against HPC token. It does betting, gambling, and adult website is in no way even remotely connected with the offense.
HPZ token is dealing with Bitcoin.
It's different. It's totally different. Now coming to 87. This is also the director. Same. I'll just read the relevant part. It's just copy paste. Second para. Hence, he has knowingly assisted the petitioner in generating process of crime. That is, I have generated process of crime through betting, gambling, for adult site, and money laundering through various gaming, betting, for adult website, and cheated gullible public and is liable to be prosecuted under the provision of PMLA. 88. Third para. Just copy paste. He has knowingly assisted, I need not read. 89, serial number 89, third para, copy paste.
Hmm. 89 also.
Yes, just copy paste.
89.
May I continue? Now, as per prosecution complaint and the summary of evidence to prove the charge of money laundering against the petitioner, which is part of the prosecution complaint, Your Worship, the petitioner company has generated proceeds of crime through various gaming, betting, adult website, and cheated gullible public. And that its financial transaction, that payment of GST also, it does not match with the transaction and line of its business. In no way it is remotely connected with the predicate offense which is under investigation. That is the complaint against HPC2. So, may I take your, for a moment, may I take your worship to page 29. Page 29. Worship does not do.
Yes.
So, the last line, this is the grounds of challenge, Worship, my ground. For that, the entire case of the respondent is based upon presumption and no supporting credible evidence has been filed with the learned trial court so as to substantiate the allegation against the petitioner. And 5, that there is absolutely nothing on record to show that the petitioner herein is in any manner connected with the alleged offense. That is the predicate offense, the complaint against HPC2. So this is one of the grounds which I have taken. And unlike in the case of HPC token, there is no complaint. And registration of complaint FI is the foundation for the respondent to exercise his jurisdiction. So no complaint, which is the foundation for the respondent to exercise his jurisdiction and to investigate under PMLA against the petitioner, is registered before any authority for cheating gullible people by use of gaming, betting, or adult website. So that foundation is missing to exercise jurisdiction. Therefore, one of the grounds which I have taken is that the entire case of the respondent against the petitioner is based purely on presumption. And in my respectful submission, the respondent must exercise his authority as provided under PMLA, more so, Lordship, more so when the offense under Section 3 has serious penal consequences. Lordship. Cannot be merely on presumption. Now, may I take your Lordship to the provision, Section 3 of the PMLA. Lordship has got it. Offense of money laundering, this is defined. Whoever directly or indirectly attempts to indulge or knowingly assists or knowingly is a party or is actually involved in any process or activity connected with the process of crime. I will take your Lordship to the process of crime, the definition, including its concealment, possession, acquisition, or use, and projecting or claiming it as untainted money shall be guilty of offense of money laundering. When I have no connection with that predicate offense, the question of receiving or being involved with process of crime from the predicate offense does not arise. Here, this Section 3 has to be read with Section 2(1)(u), which defines the process of crime. What is process of crime?
2(1)(u).
1U. 1U and 1Y. These are the three relevant provisions. Lordship has got it. 1U. 1U. Lordship has got it.
Section 2.
2(1)(u).
2(1)(u).
Yes. The process of
Oh, yes, yes.
process of crime means any property derived or obtained directly or indirectly by any person as a result of criminal activity. In this case, your Lordship, my humble submission, the criminal activity is the complaint offense alleged to have been committed by HPG in this case. Relating to a scheduled offense, and it must be a scheduled offense, and I'll satisfy your Lordship that I'll take your Lordship to the schedule. Betting, gambling, adults is not a scheduled offense under or the value of any such property or where such property is taken or held outside the country than the property equivalent in value held within abroad. Just relevant portion is. So I must have directly or indirectly must have received some process of crime in connection with a criminal activity relating to a scheduled offense. In this case, the criminal activity which is under investigation is the FIR, the predicate offense, allegation against HPG token. Now, the scheduled offense, what are the scheduled offense? The scheduled offense is at Section 2(1)(y). I will take your Lordship to that, but scheduled offense is defined under Section 2(1)(y), your Lordship. In the course of my submission, I will take your Lordship to the schedule.
Now,
Yes.
so, Your Lordship, in order to constitute the offence of money laundering as defined under Section 3 PMLA, the process of crime must be connected either directly or indirectly with a criminal activity, which is under investigation, and must relate to a civil offence under the PMLA. In the present case, at the cost of reputation, the criminal activity is the complaint or FIR against HP's token. This is the predicate offence, the offence from which the illegal money has been generated. Now, Your Lordship, in the entire prosecution complaint and also in the summary of evidence to prove the charge of money laundering against the petitioner, there is not even a whisper that the petitioner, either directly or indirectly, attempted to indulge or knowingly assisted or knowingly is a party or is actually involved in the process or actually connected with the process of crime derived from HPG token, including its concealment, those does not arise when have not derived, or possession, acquisition, or its use, or project claiming it as intended property so as to be guilty for committing an offence of money laundering as defined under Section 3 PMLA. Now, their own statement recorded in the prosecution complaint and also the summary of evidence to prove the charge of money laundering against the petitioner, Your Lordship, it is stated, it is on record, that while investigating the process of crime that flowed from the predicate offence, HPG token, that is the complaint against HPG token, the respondent also happened to investigate the petitioner company and found that the petitioner company, through various gaming, betting, adult websites, have generated or received proceeds of crime. And by cheating gullible public, whatever. And that the financial transaction of the petitioner company is also not as per the line of business. So, admittedly, their own record, Your Lordship, the alleged process of crime received or generated by the petitioner company is not even remotely connected with the predicate offence. That is the complaint or FIR filed against HPC token before the cybercrime PS Kohima. And moreover, Your Lordship may kindly also take note of the fact that betting, gambling, and adult website is not a civil offence under PMLA. Being so, the respondent does not have jurisdiction to investigate against the petitioner in connection with ML case number 1 of 2024 under PMLA. But for reason best known to the respondent, Your Lordship, the petitioner is found guilty of offence of money laundering and accordingly named as accused number 85 in the prosecution complaint. So being agreed, the petitioner is before your...
So investigation is going on?
No, investigation complaint, prosecution complaint, prosecution complaint, in fact, it's a charge sheet.
Oh, charge sheet.
It's a charge sheet. ECIR is more or less FIR, but then prosecution complaint is equivalent to charge sheet.
So trial has started, that means?
Not yet, Your
Not
Lordship.
yet.
Not yet.
CC is yet to be framed.
Someone was issued
Oh,
to.
okay.
Someone has been
issued?
I am also...
It's very
for
initial
court
stage.
Okay, initial stage.
And I am accused number 85. I think my turn will not come soon.
Not come now.
As per this, There are 299 accused in the process, and I am told that supplementary prosecution complaint, charge sheet also has been filed, and together with this, there are about 500,
450 accused.
400,
50 accused.
and it may increase also.
May
That is
increase.
what they are saying. But then anyone with candidate, they cannot just bring, I don't know, but anyway, I have nothing to say on that. I am just presenting my case, So, being aggrieved, Your Lordship, the petitioner is before this honorable court.
The original FIR was against HPZ. token.
SPZ token.
I think that all those other cases,
Yes, yes,
Bhupesh,
yes,
Arora,
yes,
and all,
yes,
they are
same
all
case.
connected
Main
to
accused.
this,
Same case.
isn't it?
Main accused.
Same case.
They are the main accused. Bhupesh Arora is the main accused. Now, Your Lordship, petitioner has taken several grounds, including question the legality of the summon order issued by the special court PMLA on the ground that it has been issued mechanically without application of judicious mind, and also I have also taken to one of the ground that it is criminal proceeding has been initiated against the petitioner purely based on presumption, right? But
Okay, now,
but since I am praying for washing, Your Lordship, so my the main ground, Your Lordship, may I take Your Lordship to para 17, page 17. Because if the proceeding is quashed, the others are all consequential. So I will be mainly restricting my submission on this. 17.1.
page
Ground.
17,
Ground.
ground.
Ground, Your Lordship. Roman 1. For that, the respondent has illegally arraigned the petitioner in the present proceeding because, admittedly, neither any civil offence exists against the petitioner, nor any money trail of proceeds of crime has been shown to have flown to the petitioner. I have taken Your Lordship to the flow chart from the predicate offence. Only allegation against me is that I am involved in gaming, betting at the website, and thereby generated illegal money. B. The mandatory condition for initiation of investigation under PMLA is either one is accused of a civil offence or has any connection with the process of crime generated by any accused of the civil offence. Now, next, I have quoted to you, but these are provisions which I have taken. Now, next is page 20, C, ground C. Bottom, last para, Your Lordship has got it. That from the perusal of aforementioned provision of PMLA, it can easily infer that for arraignment of a person under PMLA, following essential prerequisite conditions are required to be fulfilled. That is reading section 3, 2.1u and 2.1y. Page 21. There must be a civil offence as defined in section 2.1y of PMLA. 2. The civil offence must result in process of crime, that is, any property derived or obtained directly or indirectly from criminal activities. As I have said, at the cost of repetition, criminal activities is the offence or the allegation made against HPC relating to the civil offence. And 3. There must be a nexus between the civil offence and the alleged laundering activity, be it direct or indirect. D. Whereas in the present case as detailed above, it is the admitted case of the respondent that alleged activities highlighted by it has no nexus with the FIR accused person, that is HPG token, nor any connection has been found with the process of crime generated by the FIR accused person with the business activity of the petitioner hearing. Therefore, the entire case of the respondent is liable to be quashed solely on the basis on this count alone. I have taken to the other ground regarding presumption, Your Lordship. Now, may I take Your Lordship to my prayer? Page 31. Para 11, 1. Allow the petition by quashing and setting aside. Impugn summoning order dated such and such passed by this summon order Now B, impugn prosecution complaint, which I have read out, Lordship. Now C is the impugn order dated such and such, and Your Lordship, just for your easy reference, impugn summoning order is at page 36 to 37. Lordship can just write down for easy reference.
Page
36 to 37.
36 to 37.
37. And D, prosecution complaint is from page 38 to 450.
38 to 450.
450. And then the impugn order, this is passed by the adjudicating authority, page 451, 451 to 564.
564.
564. This, by this information of the provisional attachment order. D is provisional attachment order, which is page 565 to 632, 632. And E is the ECIR, Enforcement Case Information Report, page 633 to 635. But Your Lordship, if the proceeding in respect of the petitioner in connection with ML case number 1 of 2024 is interfered with, Your Lordship, all other
Then all
cases
the
becomes
others are consequential.
Now, petitioner is praying for the relief on 4 grounds. On 4 grounds. Firstly, gaming, betting, and adults website is not a scheduled offense under PML. Gaming, betting, and adult website is not a scheduled offense under PML. May I take Your Lordship to the schedule? Lordship has got it. Lordship has got it.
Yes, the schedule.
Part A,
Yeah,
para
part
1 is
A.
offense under IPC. Para 2, next page. Para 2 is offense under NDPS. Lordship has got it. Para 3, offense under Explosive Substance Act. Para 4, offense under Unlawful Activities Prevention Act. And unlawful activities, Your Lordship, it relates to terrorist activities, not with gaming, betting, adult website. Para 5, offense under Arms Act. Lordship. Para 6, offense under Wildlife Protection. Para 7, offense under Immoral Traffic Prevention Act.
Wait,
Nah.
wait. Is there an amendment to the PMLA?
Para 7.
Because the paras are not tallying.
This is
This is 2002.
2002.
I think this is a
2009 edition, this one.
prevention of money arrangement of section. This is
Because here, in para A is IPC, para 2 is NDPS, and then part B. Then comes part B.
then I think in yours, I think even 420 may not be there. In
420
IP
is not there.
Yes, but here 420 is there. I think
I think
it is in your 420.
420 is there, IPC.
Yes, yes.
Here only 121 and 121A is there.
No, 420 is there. Where is 420?
420 under the schedule offense.
If, even ED does not have 420. So they have not.
Because your edition is 2002, your act. Your Bear Act.
2002.
This is 2009. In the schedule, it is only paragraph 1, it is offences under IPC, paragraph 2, offences under NDPS. Then comes part B, offences under
In my
IPC.
old one, there was no 420, so I said, how can ED exercise jurisdiction?
120B is there.
Here it is not there. Do you have another
But anyway,
copy? Let's see. Let's see. Same. Let me see. Let me see.
Anyway, Lordship, I don't need mine, but just Lordship make cross
No,
check.
no, no, I got it, I got it.
Yes.
So, schedule part A, paragraph 1, IPC, 120B is there.
In earlier one, it was not there.
121,
420 is
121A,
there.
then 420 is also there.
Yes.
Yes, yes.
So, in short, Your Lordship, your Lordship, so betting, gambling, adult website, in short, there are many paragraphs, Your Lordship, 21. So, it is not there. That is my issue. So, betting, gambling and adult website is not a scheduled offence under PMLA, and therefore, as per law laid down by Honorable Appeals Court, respondent does not have jurisdiction to proceed against the petitioner under PMLA. And here, I will be referring to Vijay Madanlal Chaudhary's case. It is reported in 2023, 12 SCC 1. In fact, Lordship, in Vijay Madanlal Chaudhary, the schedules are also there. Now, I am relying on paragraph 382, page 306. .8, page 306.
82.8.
Lordship has got it?
Yes.
I will just read 2 lines. Remaining will be in the course of my submission. The offence under Section 3 of PMLA Act is dependent on illegal gain of property as a result of criminal activity relating to a scheduled offence.
Offence under dependent on legal gain properties.
Lordship, clear?
Yes.
Now, so my case is that as betting, gambling, adult website is not a scheduled offence under PMLA, there is no cause of action for the respondent to proceed against the petitioner under PMLA. As such, proceeding initiated against petitioner company for money laundering under Section 3 of the PMLA is not only contrary to the provision of PMLA, but is also without jurisdiction and against the principle of law laid down by the Honorable Appeals Court. That is my first submission. Secondly, my second ground, even assuming but not admitting that gaming, betting, and adult website is a scheduled offence under PMLA. Supposing, assuming it is a scheduled offence, the respondent can initiate proceeding under PMLA against the petitioner only if a complaint is registered with the jurisdictional police against the petitioner company for its alleged involvement in gaming, betting, and adult website. A complaint must be registered within the jurisdictional police against the petitioner company so as to give jurisdiction to the respondent to investigate under PMLA.
Yes.
And as per material available on record, no complaint is registered against petitioner company for its alleged involvement in gaming, betting, and adult website. In other words, there is no predicate offense. And so, which is the foundation. So, in absence of predicate offense, initiation of proceeding under PMLA by respondent against petitioner company is also contrary to the law laid down by the Honorable Appeals Court in the same case, Vijay Madan Lal Chaudhary. I'll take your lordship to the same paragraph, para 382.8, same paragraph. The fourth line, the authority, lordship has got it? The authority under the 202 Act, this is PMLA, cannot prosecute any person on notional basis or on the assumption. This is my case, the ground which I have taken on presumption and assumption, that a scheduled offense has been committed unless it is so registered with the jurisdictional police and or pending inquiry, trial, including by way of criminal complaint before the competent forum. A complaint has to be there. So, as per the law laid down by the Honorable Appeals Court in Vijay Madan Lal Chaudhary, existence of a predicate offense is a jurisdictional fact, and in absence of predicate offense, the respondent cannot initiate any criminal proceeding against the petitioner under PMLA. Now, third ground. The proceeding against petitioner company is contrary to section 66(2) of the PMLA. I hope the version will be the same.
Yes, no.
Yes, 66(2). Lordship has got it?
Disclosure.
Yes.
Disclosure of information.
So 66(2). If the director, not now. If the director or other authority, Lordship has got it? If the director or other authority is specified under subsection 1 is of the opinion on the basis of information or materials in his possession that the provision of any other law for the time being in force are contravened, then the director, like in this case, while investigating HPG Tukun, they have come across, they have investigated petitioner's company. So then the director or such other authority shall share the information with the concerned agency for necessary action. Now, this section 66(2) has been dealt with by the Honorable High Court of Madras in Your Worship, in RKM Powergen Private Limited, which is reported in 2025 SEC Online, Madras 3272. In this case, Your Worship, in the bold it is given, say, prayer in writ petition 4300. This is forbearing the respondent from proceeding in investigation. This is all writ petition. Also, all together 4 writ petitions were taken up. May I take Your Lordship to the relevant paragraph, last paragraph 60 to 63, 3 paragraphs I'll read out. Para 60 to 63. Lordship has got it? Yes. It is too well settled that where an act has to be done in a particular way, it must be done in that way and in no other way. The PMLA demands the existence of a predicate offense when there is no predicate offense, initiation of proceeding under PMLA is a non-starter. In this case, Your Lordship, in the present case, there is no predicate offense, Your Lordship. If the argument of the additional Solicitor General is accepted, then the ED on registration of an ECR can conduct a roving inquiry with respect to other aspects also. And this is the stand which they have taken in the affidavit of opposition by relying on section 22 to 24. That is not the position of law. To put it bitterly, no predicate offense, no action by ED. Predicate offense is the foundation. 61. A careful perusal of section 66(2) of PMLA points out that if during the course of investigation, the AD comes across violation of other provisions of law, like in this case, but in this case, these are not a schedule offense, then it cannot assume the role of investigating those offenses also. This is what they have done in the present case. It is to inform the what ED has to do is, it is to inform the appropriate agency which is empowered by law to investigate into that offense. If that agency, on the intimation from the ED, commences investigation and register a complaint, then certainly ED can investigate into those aspects, also provided there are proceeds of crime. Complaint is the foundation. They cannot make a roving inquiry. Now, 62. As there is no predicate offense with respect to the three aspects of paragraph number 7 of the counter, here it relates to allotment of whole zone here, Your Lordship. We concluded that the impugned order suffer from jurisdictional error and the other order of attachment is perceived without jurisdiction. Even I am also quashing of that attachment order. 66. Unless and until proceeds of crime linked to the predicate offense are shown, in the present case, linked to the predicate, that is the HPG token. ED, by virtue of a combined reading of section 21U, 21B, 3, read with section 70, does not have the power to proceed further. In fine, lacks the jurisdiction to proceed further. In the light of the above decision, the impugned order such and such is allowed with cost. Even cost has been imposed in this case. And in my respectful submission, Your Lordship, the case of the petition is squarely covered by this. Because as per prosecution complaint and also the summary of evidence to prove the charge against the petitioner, Your Lordship, while investigating the process of crime that flowed from the predicate offense, Your Lordship, that is the HPG token, the respondent also happened to investigate the petitioner company and found it to be engaged in betting, gaming, and adult website, and thereby generated process of crime, illegal money. But there is no complaint filed against the petitioner in respect of in connection with this betting, gambling, there is no complaint. So if there is no predicate offense, no investigation by the respondent. And the foreground which I have taken, Your Lordship, that is on presumption. It's purely based on presumption with no supporting evidence, and criminal proceedings cannot be initiated based purely on presumption and assumption, and more so under PMLA, which provides for serious consequences. Now, may I The respondent has filed affidavit in opposition. So, in order to save his time, may I read out? So, even though I don't read, he will be reading. So, let me take the trouble of reading the affidavit in opposition.
Okay. One minute, huh?
Page 20, the grounds for opposing the petition.
Page.
Page 20, para 19 is the ground which they have taken to oppose the prayer of the petitioner. But I'll read from para 21. At the outset, the petitioner proceeds on an inert assumption that unless a person is arraigned as an accused in the scheduled offence, no proceeding can be initiated against such person under the PMLA. The said proposition is wholly unsupported by the provision of the Act. Neither Section 2U, Section 2Y, nor Section 3, this should be 1U, one is missing, nor Section 3 of the PMLA mandates that a person must necessarily be named as an accused in the scheduled offence before being proceeded against the PMLA. Now, Your Lordship, I have never submitted, it is not my case that the petitioner, as he is not arraigned as an accused in the ACR, or that is not my case. Now, my case is that in order to constitute the offence of money laundering, the process of crime must be connected either directly or indirectly with the criminal activities. That is the offence which is under investigation. There is a complaint against H.P.C. Tukun, which is a predicate offence. And there's nothing in the prosecution complaint or in the summary of evidence to prove the charge to connect the petitioner company with the predicate offence. That is my case. It is not that I am not, since I am not arraigned, I cannot be investigated. No. And moreover, even as regards my involvement in the alleged involvement in betting, gaming, and other website, Your Lordship, no complaint is registered so as to give jurisdiction to the respondent to investigate under PML. So when there is nothing to establish petitioner having received proceeds of crime from the predicate offence, and also when no complaint is filed against the petitioner company for its alleged involvement in betting, gaming, and other websites, Your Lordship, initiating criminal proceeding against the petitioner company amounts to clear abuse of the process of law, which cannot be permitted. Now, para 22 of the affidavit of opposition. It is submitted that the statutory requirement is the existence of a scheduled offence and the generation of process of crime therefore. This is their own statement. Existence of a scheduled offence. Once proceeds of crime are generated from a scheduled offence, any person who is found to have directly or indirectly assisted, been involved or knowingly, this is correct. But my case is that I am in no way connected. They have from their own record, the possession complaint, summary of evidence, Your Lordship, there is nothing to show the connection. Either directly or indirectly being involved in the commission of the civil offence or having received any process of crime. Now, para 23 and 24, these are contained. That the petitioner's contention that no scheduled offence exists against him is legally untenable. No. The Act will show that. The relevant consideration is not whether the petitioner is accused in the scheduled offence, but whether a scheduled offence exists and whether material gathered during investigation discloses the petitioner's involvement in activities connected with the process of crime generated therefrom. It must be from the predicate offence, not from betting, gaming, adult website. The investigation has revealed such material which forms, and this is absolutely false. There is nothing. There is not even a whisper. 24. The further contention that no nexus exists between the scheduled offence and the activities under investigation is specifically denied. The investigation has traced the flow and utilization of funds. I have given the chart, flow chart, through various entities, accounts, part payment gateway and financial channel and has revealed the petitioner's role in transaction connected with the process of crime. The existence, nature and extent of such nexus are matter borne out from the evidence collected during investigation and cannot be conclusively adjudicated in proceedings seeking caution. Now, Your Lordship, as per prosecution complaint and also the summary evidence, Your Lordship, while investigating the process of crime that flowed from the predicate offense, that is the complaint against SPG Tukan, the respondent also happened to investigate at the cost of reputation the petitioner's company and found that the petitioners through various gaming, betting and other websites generated or received proceeds of crime. And even the financial transaction of the petitioner is not as per the line of business. So, admittedly, from their own record, the alleged proceeds of crime, Lordship, though received or alleged to have been received or generated by the petitioner's company is not even remotely connected with the predicate offense, that is the complaint or FIR filed against HPG Tukan before the survey and PS Kohima, Lordship, and also the prosecution complaint filed in connection. Moreover, at the cost of repetition, not only betting, gaming and other website is not a scheduled offense, but no complaint or FIR has also been registered so as to give jurisdiction to the respondent to investigate under PML. Lordship. Now, para 25. Petitioner is attempting to selectively rely upon isolated portion of investigation. No. Then the respondent is at liberty to show more. Yeah, this is what is stated in the proceeding code. I have not relied selectively. This is as per the record. Para 26. It is therefore denied that proceedings are liable to be quashed on the ground that the petitioner has not been named as an accused in the FIR. This is not my case. The existence of the schedule offense, generation of process, and the petitioner's connection with activities relating thereto, where nothing. Because betting, gaming, and adult website is not even remotely connected with the predicate offense. Or the FIR or schedule offense alleged to have been committed by HPG Tukan. Therefore, the grounds taken by the respondent in opposing the prayer of the petitioner or the petition are not legally sustainable. Now, another ground taken, Your Lordship, so I'll just save the trouble of my learned friend. Page 16. You must be going to page 16 of affidavit in opposition.
Page 16 of the affidavit.
Affidavit in opposition. Here, the respondent authorities has relied on section 22, 23, and 24 of PMLA. May I take Your Lordship to the Act? Section 22, 23, and 24, Your Lordship, is part of Chapter 5. Chapter 5 is from, and Chapter 5, Lordship has got it, deals with summon, searches, and seizures. Lordship has got it? Chapter
Summon,
5.
searches and seizures.
That is when offense is investigated under Section 3. Then only this will come. In my case, Section 3 does not come into play. In fact, respondent does not even have jurisdiction to investigate. Now, Your Lordship, another. May I take Your Lordship to page 6, the last, this will be the last. Page 6 of the affidavit in opposition. C. Lordship has got it.
Yes.
This is part of para 5. At the outset, is respectfully submitted the present petition, though style and file under section 482 of the. Now they have raised a technical objection on maintainability. That this is not maintainable. 482 CRPC, section 528 of BNSS is in substance, and here this petition is read with article 226 and 227, Your Lordship. The petitioner seeks to challenge an order passed by the learned special court, magistrate, whatever. I will skip this, and they have relied on next page, Your Lordship, to substantiate. Page 7, one case, second line, Bipin Sahini, another versus CBI. Lordship has got it?
Bipin Sani,
Yes. And then last paragraph, two case law they have relied on. Third line from the bottom, RT Rai, Lordship has got it. Rajan Kumar Manchandra. Now, yes, these are the three authorities they have relied on in support of the preliminary objection raised by them on maintainability. Now, Bipin Sani and others, first case, I'll just take your Lordship to para 23.
Para
23. What was the case here? May I read out? As regards the objection raised by the petitioner as regards the maintainability of the CBI petition filed before the High Court under section 482, this is a file under 482. Here I have added 226 also. We may note that as per Article 131 of the schedule to the limitation whatever, the limitation period for filing of criminal revision, that is limitation period, it is before the High Court or the Session Court is 90 days. However, there is no limitation prescribed for invocation of the inherent power of the High Court under section 482, and it can be at any time. It is a matter of record that when the learned special magistrate CBI Court dismissed the appellant discharge petition in the first instance, they had filed a revision before the Session Court under 397, and the matter was remanded for hearing afresh. However, the CBI did not choose to adopt this course when the appellant discharge petition was allowed by. This is the discharge. This is the final order. Now here, para 28, this is of Mohit Sahu, Lordship. So far as inherent power of the High Court as contained under section 42 CRPC is concerned, the law in this regard is set at rest by this court in the Kakina objection. However, we would like to reiterate that when an order not interlocutory, in the present case, Your Lordship, what I am telling you is the proceeding, not a final order. Except the summon order is also an interlocutory order. It's not a final order, Your Lordship. So this is not applicable. Next case. Next case is shorter, only just relevant portion I will read out. Dipti. Dipti, which 1995, 5 SEC. Para 4. Third line from the bottom. The second revision application after dismissal of the first one by Session Court is not maintainable, and that inherent power under Section 42 of the Code cannot be utilized.
Where is that? Para 4.
Para 4, third line from the bottom. It should have also applied to mind to the aspect that second revision. There is a second revision. Yes, because it is barred by Section 397(2)(3), Your Lordship. So this case is not relevant at all. Now next case is 1990 Supply SEC 132. Third, the learned counsel for parties, para 2.
Yes, para 2.
Yes. Third, learned counsel for the parties. The respondent state had challenged the order before the court of session when the learned magistrate before whom the matter was proceeding directed release of the trust in favor of the appellant. The revisional court dismissed the petition of the state. The second revision did not lie at the instance of the state. This is also second revision. Obviously, to avoid this part, the application moved by this. In order to avoid this, the High Court was stated to be under Section 42, asking for excess of inherent power. In excess of the power, the High Court has reversed the order of magistrate as affirmed by the session judge. The question for consideration is as to whether the bar under Section 3973 CRPC should be taken note of to reject the revision at the instance of the state government, or action taken by the High Court in excess of its inner has to be sustained. It is not disputed by counsel appearing for the state that the move before the High Court was really on application for revision of an order of magistrate releasing drug. That is actually what is provided under Section 397. Merely by saying that the jurisdiction of the High Court for excess of inherent power was being revoked, the statutory bar could not have been overcome. If that is to be permitted, every revision application facing the bar under Section 40 court could be labeled as one under Section 42, where certified there is a case where High Court has no jurisdiction to entertain the revision. Now, this also relates to second revision. Now, in opposing the prayer, Your Lordship, now may I take Your Lordship to page 8? This will be my last.
Page 8.
8. E. On the ground that it is not maintainable by relying on bhajan law. E. Your Lordship has got it? I will just read out the italic one, relevant para. In excess of the extraordinary power under 226 of or the inherent power under Section 42 of the Code of Procedure, the following categories of cases are given by way of illustration when 42 and 226 can be exercised, wherein such power should be exercised, either to prevent abuse of the process of any court. Here I am on that. Otherwise, to secure the ends of justice, I am also praying for justice. Though it may not be possible to lay down any precise, clear, defined, and sufficiently channelized and inflexible guide in myriad kind of cases where such power should be exercised. 1. The principle. Where the allegation made in the first information report or the complaint, even if they are taken at the face value and accepted in their entirety, do not prima facie constitute any offense or make out a case against the accused. My case is covered by this, Your Lordship. Lordship, may I rephrase it like this? A. Lordship may kindly, where the allegation made in the prosecution complaint, because there is no FIR, even if they are taken at the face value and accepted in their entirety, do not prima facie constitute any offense or make out a case against the petitioner for being guilty of offense of money laundering. This is my case. B also covers my case, where the allegation in the first information report and other material, if any, accompanying the FIR, do not disclose a commercial offense justifying an investigation under police officer such and such. Here, Your Lordship, my case is this. The allegation in the prosecution complaint and also the summary of evidence accompanying the prosecution complaint do not disclose commission of offense of money laundering, justifying an investigation by the respondent under Section 3 of PMLA. Your Lordship. Now, next C. Let me rephrase it like this. Where the uncontroverted allegation made in the prosecution complaint and the evidence collected in support of the same do not disclose the commission of the offense of money laundering and make out a case against the petitioner company. C also covers. D also. Lordship, I'll be rephrasing it. Where the allegation in the prosecution complaint instead of FIR do not constitute commission of offense of money laundering, no investigation is permitted by the respondent under PMLA, Section 3 of the PMLA. Lordship. E. Where the allegation made in the prosecution complaint relates to betting, gaming, adult website. No prudent person can ever reach a just conclusion that there is sufficient ground for proceeding against the petitioner company for committing an offense of money laundering in connection with the predicate offense. F. Where there is an express bar, in this case, Your Lordship, if there is no predicate offense, no offense of money laundering, as per the law laid down by the Honorable Appeals Court, under PMLA to institution continuous of proceeding, Your Lordship. So far as the second part is concerned, that is alternate remedy. G, where a criminal proceeding is manifestly attended with malafide and or where the proceeding is maliciously instituted with ulterior motive for wreaking vengeance on the accused and with a view to spite him to private and personal crush. In the present case, Your Lordship, when I am in no way connected with the predicate offense, Your Lordship, initiating criminal proceeding against the petitioner is with ulterior motive, Your Lordship. If G, Your Lordship, G, I'll be referring only to, by relying on this, the case has been referred to Naraka infrastructure, principle with respect to quashing of criminal proceeding. I'll be here, I'm relying on their own case law, also own authority, everything, their own documents, Your Lordship. Now, may I take Your Lordship to the principle laid down, page 12. Lordship has got it. Page 12, para Roman small 13. The power under section 482 CRPC is very wide, but conferment of wide power requires the court to be cautious. It casts an onerous and more diligent duty on the court. 14. However, at the same time, the court, if it thinks fit, regards being held to the parameters of quashing and the self-restraint imposed by law, more particularly the parameter laid down by this court in R.P. Kapoor Bhajanlal, has the jurisdiction to quash the FIR complaint. So, when a prayer for quashing, 15, when a prayer for quashing the FIR is made by the alleged accused, the court, when it exercises power under section 482 or 126, only has to consider whether or not the allegation in the prosecution complaint disclosed the commission of offense. In the present case, Your Lordship, the prosecution complaint and the summary of evidence to prove the charge against the petitioner company, Your Lordship, does not disclose anything to establish the commission offense of money laundering as defined under section 3 by the petitioner in connection with the predicate offense. Therefore, in my respectful submission, this is a fit case which calls for the intervention of this honorable court in excess of power under 482 and also 226 of the petitioner, Your Lordship. Now, just to sum up, Your Lordship, first, there is nothing to establish that petitioner received any process of crime from the predicate offense. Secondly, betting, gaming, adult website is not a scheduled offense under PMLA. Thirdly, even assuming but not admitting that betting, gaming, and adult website is a scheduled offense under PMLA, the respondent can initiate proceeding under PMLA against the petitioner company only if a complaint is registered with the jurisdictional police against the petitioner company. As per record, no complaint has been registered till date against the petitioner company. Fourthly, proceeding against the petitioner company is contrary to section 66 of the PMLA. Fifthly, the case of the petitioner is absolutely based on presumption and assumption with no supporting evidence. Sixthly, the proceeding against the petitioner in connection with ML case number 1 of 2024 before the Special Court PMLA Dimapur is not only contrary to the provision of PMLA 2002 but also against the law laid down by the Honorable Appeals Court. Therefore, this is a fit case which calls for intervention of this Honorable Court in order to prevent abuse of the process of law and in the interest of justice by granting the relief as prayed for by the petitioner. I am deeply obliged. I conclude.
Yes. Most of your contents have already been read out.
Yes, your Lordship, I will not repeat all those things.
So don't repeat those.
However,
Yeah.
the brief fact of the case, within few minutes I will sum up, your Lordship. Your Lordship, kindly take page number 13, your Lordship, of my affidavit in opposition.
Page 13, yes.
Yes, your Lordship. I will read it very fast so that within few minutes I will finish it, your Lordship. Your Lordship, 6.1, that brief fact of the case. That based on the complaint against SPG token and other disclosing that, your Lordship, this is an economic offence where more than 1,000 crore money has been looted from the global investor. So the SPZ token and other disclosing that thousands of persons were dubbed by this entity on the pretext of receipt of investment of Bitcoin mining. The cybercrime police station Kohima, Nagaland registered an FIR number 3 of 21 dated 8/10/21 under section 420 and 120B of IPC read with 66D of the IT Act. So, as regards to this, the Kohima crime police station have registered a case under section 420 and 120B of IPC read with 66D of the IT Act. Your Lordship, 6.2, that offences under section 420 and 120 of IPC fall under paragraph 1, part A of the schedule of offences under the PMLA Act 2002. Therefore, the matter was examined by the Directorate of Enforcement, Dimapur Sub-Zonal Office, and since prima facie a case for money laundering as defined under section 3 of the PMLA and punishable under section 4 of the PMLA was made out, a case was recorded by an enforcement case information report, that is ECIR dated 12/4/20, and investigation was initiated under PMLA. Your Lordship, here any FIR before the cyber or any police stations where there is a schedule offense, then only the ED will come in the picture, your Lordship. Now, since in the cyber crime, the sections was 120B and 420, and which comes under the purview of schedule offenses, is because
but that was against that
SPZ token, we are coming, your Lordship, that the case will be filed against any persons. But if there is any schedule offense, then the ECIR will be lodged before the ED and the independent investigation will start. So accordingly, in this case, your Lordship, crime branch has lodged an FIR and schedule offense was there. So as because of that, the ED has registered ECIR and independent investigation was started. Now 6.3, your Lordship, that pursuit of the aforesaid FIR revealed that SPZ token, an app-based token, promised users of large gains returned against investment in mining machine for Bitcoin and other cryptocurrency. The investors were assured that their invested money was being used to buy mining machines by which cryptocurrency were being mined, and they would be receiving gains against sale of such cryptocurrency. Suddenly, the application stopped working and the investors were not allowed to withdraw the money. Now your Lordship, the global investors who have invested the money in SPZ token app, suddenly that SPZ token app stopped functioning and the investors were not allowed to withdraw the money. So that is why that ECIR has been lost, your Lordship. 6.4, that investigation under PMLA revealed larger conspiracy to cheat global investor and various related entities. Role of similar apps, websites were found to be fraudulently receiving funds from public in pretext of unregistered gaming, betting, loan, etc. apps, website surfaced during PMLA investigation. Now, your Lordship, during investigation, it has been found that from the global investors, the money was received by different payment gateway. Different entities were involved. Your Lordship, even 10 Chinese companies are also involved in this case. Now, Your Honor, many entities, they receive money from the global investors and they park the money, and later on I will come how they siphon the money to the other country. That during the course of investigation, it was revealed that, now I'm coming to the petitioner's company, Your Lordship. During the course of investigation, it was revealed that Jyotisha Technology Private Limited was allegedly involved in activities facilitating fraudulent transactions and deceiving unsuspecting members of the public. Accordingly, the account statement of Jyotisha Technology Private Limited obtained from PAU Payment Service Private Limited and Hypto Inc. were subjected to detailed analysis. During investigations, it was revealed that the petitioner's company was also involved, as because of that, the company's accounts and other activities were properly scrutinized by the investigating officers. 6.6. The investigation disclosed that the merchant Jyotisha Technology Private Limited was operating through the website www.astropay.com, which offered prepaid card facilities and could be utilized on various betting and gambling platforms. The website was also found to provide services relating to cryptocurrency transactions. 6.7. Further examination revealed that the merchant was onboarded on the payment gateway platform of PAU Payment Service Private Limited under an e-commerce line of business. However, it was found that the merchant was allegedly misusing the payment gateway credentially salt and key by routing transaction traffic originated from betting and adult content website. Analysis of website traffic during the relevant period indicate substantial user activities from China and several other foreign jurisdictions on the website www.astropo.com. It was further observed that a significant volume of referral traffic associated with gambling and sports betting transactions originated from website engaged in betting related activities. Additionally, OnlyFans.com and adult content platform was identified as one of the top referring websites directing traffic to the merchant platform. The investigation also revealed discrepancy between the nature of business declared by Jyotisha Technology, that is the petitioner's company, by Jyotisha Technology Private Limited and its actual operation. While the company had declared its business activities under GST as collection agency services and financial transaction processing and clearing house services, the nature of transaction proceed through its platform and the business activities conducted through the website did not correspond with either the declared business activities or the line of business registered with the PAU Payment Services Private Limited. This finding indicate that the transaction proceed by the merchant were not in conformity with its declared and registered business activities. Your Lordship, the petitioner's company basically registered for under GST as collections agency services. However, the line of business is not matched with the declared. As that suspicions was arose there, and the investigating officer have started investigating the bank account and other transactions of the petitioner's company. It was observed that PAU Payments Private Limited had placed a hold on the PEN and out amounts pertaining to Jyotisha Technology Private Limited upon receipt of complaint from the Cybercrime Police regarding the company's suspected activities. During the course of investigation, the merchant identification accounts maintained by Jyotisha Technology Private Limited with PAU Payment Private Limited and Cash Free Payment Private Limited along with the balances available in the associate bank account were provisionally attached by provisional attachment order number 1 of 23. The said attachment was subsequently confirmed by the learned adjudicating authority under the Prevention of Money Laundering Act by order dated 35/24. Your Lordship, when the bank transaction of the petitioner's company was analyzed, It was found that there are so many suspicious transactions were there, and because of that, the deputy director under section 5 of the PMLA Act, provisional attachment order was issued, and it was also confirmed by the adjudicating authority under section 8 of the PMLA. Your Lordship,
No, but isn't that in violation of section 66 too? Because it says that during the course of investigation, if you find some material against the petitioner, then the concerned, you have to share it with the concerned investigating agency, and another complaint has to be lodged.
no, Your Lordship, here we are investigating the schedule offences. Now, since since the
Right, you are saying it's a schedule offense, but then this is because this is a different. That original complaint was against HPZ token, not against this.
No, Your Lordship,
petitioner.
SPJ token Fs have connected with so many entities to collect money from the investors, and Jyotisha is also one of them. Your Lordship, Your Lordship, I will come to that section 8 adjudicating authority while confirming, and they have also appeared before the adjudicating authority and they have filed their reply, and after hearing all the parties, the confirmation was done.
Okay, anyway, you continue.
Yes. Yes, I will come to that, Your Lordship. Before that, Your Lordship, during investigation, the statement of Director of Jyotisha Technology was recorded. I would like to read once. In page number 199 of part this petition, page number 199. Your Lordship, page number 199, 8.99.
Yes.
That summon dated 7/6/23.
Yes.
That summons dated 7/6/23 was issued under section 52 of PMLA to Mr. Hari Kishan Lal, Director, Mrs. MS Jyotisha Technology Private Limited, and he was examined under section 53 of PMLA on 10/7/23. In his statement, he inter alia stated that he has passed 7th from Sarvodaya Bal Vidyalay, West Patel Nagar, Delhi, that he was working as field worker for Inaya Forex in Vikaspuri, Delhi, that in the year 2021, Mr. Vineet Misra of Inaya Forex asked him to give his ID, and which was used to register his name for Dean, that he was appointed Director of Jyotisha Technology Private Limited. In January-February 2022, that he is being paid salary of 22,000 per month. He further stated that he used to sign company-related documents which were received by him in WhatsApp, speed post or email, that he uses to sign and send it back through email after signing the same. But he uses to provide OTP for GST filing received on his phone. The bank account of the company is operated by one Mr. Thomas, who is residing in Argentina, and mobile number of Mr. Thomas is this. He was told by Mr. Vineet Misra of Inaya Forest that as a Director of Jyotisha Technology Private Limited, he has to sign the documents related to company and provide OTP whenever it is received on his phone for GST filing. That he was offered by him rupees 22,000 per month salary as a director. That he is not aware regarding the actual business of the company. He stated that he is not aware regarding the shareholders of the company, and he has never visited the office of Jyotisha Technology Private Limited. He was asked to explain who operates the bank accounts and payment gateway accounts of Jyotisha Technology Private Limited. He stated that as per his knowledge, Mr. Thomas looks after the bank account and payment gateway account of the company, and also he operates the company from Argentina. He also stated that he does not know regarding any transaction with PAU Payment Private Limited or any other company, and he has never met or interact with any merchant of gift cards of the company. He also stated that the email ID of the company, legal@jyotishatechnology.com, is operated by Mr. Thomas and Mr. Sachin Minhas. Sachin Minhas is the another director of the company. That he is not aware who were the earlier director of the company, that he is not aware regarding the transaction of Jyotisha Technology Private Limited with iBlock Technology, and that he has never joined any AGM of the company, that he is not aware regarding the business conducted by the company, that earlier Hines and company chartered accountant used to send email to him from their email ID, that he was also getting message on WhatsApp from mobile number this of Thomas. Your Honor, basically, Your Honor, to receiving money from the investors, the HPZ token apps have utilized all these entities, and the directors, even they were not aware about the conduct of their business. So this is the layer, Your Honor. In the first layer, they collect money, 5 lakhs, 10 lakh, then again, they purchase the Aadhaar card, and even the peoples, they were not aware that they are the director of the company. Their identity card has been utilized to open an account, and in this way, Your Honor, this all the money which was taken away from the investor was parked, and gradually they distribute to other accounts, and at the end, after some layers, it siphoned to the beneficiaries. Your Honor, the Minhas, that another director who has also signed the affidavit, or who was the petitioner in the instant case, he was also summoned. The next line, Your Lordship, that summons dated 7/6/20 was issued under section 52 of the Prevention of Money Laundering Act to Mr. Sachin Minhas, Director, Jyotisha Technology Private Limited, and he was examined under section 53 of the Prevention of Money Laundering Act. Continue. Your Lordship.
Should we continue tomorrow?
Your Lordship, tomorrow we have the DBA Foundation Celebration Day.
Because I think there are some more matters, isn't it? Today's list.
Your Lordship, on Monday, because Your Lordship, tomorrow I am also involved in that celebration as a final.
Okay, part 3rd, Monday.
Monday.
We'll keep it part 3rd.
Monday,
on Monday.
Tuesday, Your Lordship.
Tuesday.
Which date, sir?
Tuesday will be 21st, no? 21st.
Yes, Your Lordship.
21st. Okay. Lord Learned Counsel, Mr. T.B. Jamira for the petitioner, and Mr. Y.P. Gupta, Learned Special PP for the ED. Matters part 3rd list on 21/7 as part 3rd item on the top of the list. Hearing. On the top of the hearing list. Okay. Oh no, this is not hearing, this is admission. Top of the admission. Admission hearing. Yeah.
Obliged.
Oblige, Your Lordship.
Yes. Yes.
Your Lordship, due to paucity of time, pray that this matter may come up on Tuesday. We are seeking a interim stay in this matter. It relates to that Erica Nut
Yes.
case. We are challenging the order passed by the Sessions Court.
Okay.
Because it lacks jurisdiction. On the matter, it lacks jurisdiction.
Due to paucity of time, list the matter. When? Monday?
Tuesday, my lord.
Tuesday? On 21/7. Yeah.
Much obliged.
Lordship, in this matter, the continuation of delay, this what is to be considered. So, since the matter is going to be listed tomorrow, so I pray that this may be taken up tomorrow, Your Lordship.
What did you say? It's an IA for continuation of delay.
Lordship, Lordship.
Oh.
We are objecting to the.
You have filed your objection?
Yes, Lord.
Tomorrow?
Yes, Lord.
Okay. Pass over for the day.
Obliged, Lordship.
Much obliged.
Many more.
May I please, Lordship? My lord, here I'm going for response number 6. My lord, I have received the status, my lord.
Okay.
My lord, the matter is still before the
Matter has been examined.
State Land Acquisition Authority, my lord.
Have you
So,
given a copy?
yes, I have already served. My lord, let the matter become after 3 weeks, my lord.
Lordship, this state land acquisition authority is not a competent authority to decide land acquisition matters, Your Lordship. And this honourable court order is not to be taken by any other authority, Lordship. Like the SLA, Lordship. It's not contemplated by any act, Your Lordship. So it's not a competent authority.
Take steps to complete the acquisition.
And also, Lordship, respondent number 7, that's the DC Zenapoto. No one has appeared for respondent number 7 yet, Your Lordship.
Notice complete.
Yes, Your Lordship. Notice was given. In fact, Your Lordship, before IA was filed, even notice was personally served, Your Lordship, along with the order of this court, Your Lordship.
Have you filed any affidavit with regard to the service? Because the office note says that return service in respect of respondent 7 is awaited.
We took steps to registered post, Your Lordship. And prior to that, we also filed a note. We also submitted a given notice directly, Your Lordship, and they have received also, Your Lordship, which we have annexed in our IA for the implement. Your Lordship.
Yes. So actually, DC should be the appropriate authority, isn't it?
He's also important, Your Lordship. So no one has appeared yet.
This is from Land Revenue. You are appearing for?
Response number 6, Home Commissioner. my lord.
6.
We took steps to register post on 21st of May, Lordship.
62, 61. Are you filing any affidavit?
My lord, earlier I've already filed on behalf of response number 6.
Saying what?
Yes, saying that the matter has been placed before the SLA,
We've also filed a
and this is
reply
the
to that.
status, my lord.
We've also filed a reply to that, Your Lordship. Saying that SLA is not a competent authority.
Because see, under the Land Requisition Act, I don't think SLA is an authority. They have nothing to do. Because it is the DC who will issue the notice, and then the proceedings have to start accordingly. So SLA actually, it has nothing to do with the acquisition process.
Yes, Your Lordship.
You see the Act, the Requisition and Acquisition Act. it has got no role to play.
Yes, since the matter has already been forwarded, my lord, TC has forwarded to the Home Commissioner Nagaland, and from Commissioner Nagaland they have forwarded to Home Commissioner, and the Home Commissioner they have forwarded to this authority, my lord. This is the higher authority, my lord.
Lordship, the order of this court is not a subject to any other authority, Your Lordship.
Let us see the order of this court. What does it say? Page.
Is it at page 11? Relevant portion is at page 23 onwards. Page 23, paragraph 33.
Considering the facts and circumstances, the respondents, particularly the DC Zenepoto, is directed to take appropriate steps to complete the process regarding the acquisition of the petitioner's land, according with the provisions of the petitioner's claim of payment of land. You take instructions, okay? Because
Yes, ma'am.
as far as this court's order is concerned, it only says to acquire the petitioner's land in accordance with the provisions of the Nagaland Requisition and Acquisition Act. So, as per that, the State Land Acquisition Authority, the SLA, has no role to play actually. So, you get further instructions because otherwise, their intention is there to acquire the land. That is. Learned counsel for the petitioner, Ms. Esther, is present. Stop. The learned counsel, Mr. Itibapom, appearing for respondent number 6, has submitted a communication from the Land Revenue Department dated 3rd July 2026, by which it is stated that the matter has been examined for outright purchase of the BSNL occupied land at Old Town Colony, Zeneputo Town, and is accordingly placed for consideration by the State Land Acquisition Authority under bracket SLAA in its next meeting. Stop. Learned counsel for the petitioner has submitted that the State Land Acquisition Authority has no role to play in the acquisition process in accordance with in the acquisition process under the provisions of the Nagaland Requisition and Acquisition Act 1965, and the specific direction of this court was to acquire the land of the petitioner in accordance with the provisions of the Nagaland Requisition and Acquisition Act 1965. Stop. Para. In view of the said objection raised by the learned counsel for the petitioner, the learned counsel for the respondent number 7 shall
Six,
shall obtain further instructions in the matter. So please the same after 3 weeks.
3 weeks, ma'am.
So, and in the meantime, you inform the respondent number 7 also,
Yes, ma'am.
because he has already received notice, and if he doesn't file his affidavit or if he's not represented, then he may have to come in person.
Yes, ma'am. Much obliged.
Item 16. Yes, what is this?
Leadership, Lordship, notice for respondent 3, 4, and 5 is still awaited, Lordship.
Awaited.
Lordship.
Learned counsel for the petitioner, Mr. L. Pong, is present. Learned counsel, senior government advocate, Mr. K. Angami, is present for the respondents number 1 and 2. Stop. The notice, the service of notice on the respondents number
3, 4, and 5. Lordship.
3, 4, and 5 is still awaited. So list after 3 weeks.
Lordship,
Awaiting service.
there is an interim, Lordship.
Awaiting service report on the respondents 3, 4, and 5. So the interim order passed earlier shall continue till the next date of listing. Yes.
Lordship.
Item 19.
Lordship, I beg to appear for item number 19, Your Lordship, for the petitioner.
Lordship, office notes say that, Lordship, notices to the respondent number 2 and 3. For 2, it's awaited, and your Lordship, for 3, it is saying that it's insufficient. Redress is insufficient, your Lordship.
So what do you do for 3? You have to ascertain the correct.
Lordship, whatever the address that is given in the FIR, we are assailing an FIR here, your Lordship, for quashing. So whatever the address that has been given in the FIR, we are only supplied there.
The respondent 3 is the complainant.
Complaint.
There are dual complainant, your Lordship.
2 and 3.
2 is, we have already seen that it is awaited.
Who is 2? Who is 2?
Your Lordship,
1 is state of Nagaland. 2,
2 and 3 are the complaint.
who is your Lordship? Alok Yapthumi, and your Lordship, H. Hengsham is the.
What are they? 2 and 3, what are they in the present case?
Your Lordship, they are complaining. They are students. I am running. Complaining, your Lordship.
Okay.
But Lordship kindly sees, interestingly, what is happening. Lordship kindly sees the letter of complaint on page number 80, not 82, 76, your Lordship.
Acha, can the concerned OC serve the notice through the police station?
Lordship.
They are at Zunipoto.
Okay.
One is at Zunipoto, one is in Longling.
Yes, your Lordship.
No, but
Lordship, page number 76 is the letter of complaint, your Lordship.
there is thing in Kohima only. One is Leary Colony and one is Upper Chanmari.
Lordship. Then in that case, Lordship.
Let it be done through you do it through the concerned police station, jurisdictional police station. Okay.
Lordship.
Learning counsel for the petitioner, Mr. D. Sen, Debayan Sen is present. Stop. Learned PP, Mr. Vijay Momi is present. Stop. The notice on respondent number 3 has returned unserved with the postal remark under inverted commas insufficient address. Stop. In respect of respondent number 2 also, the service is not complete. Stop. Accordingly, the petitioner is directed to take steps for notice on the respondent number 2 and 3 through the jurisdictional police station.
State crime police station.
Through the jurisdictional police station. Let the petitioner give the copies to you and then you can serve.
Lordship, will do that.
And give it to the concerned.
Lordship, since they also have the local, so they can serve it through the state crime police station. To the OC.
Okay. Through the jurisdictional police station. Okay, because this will be, I think Chanmari will be, both will be South PS, I think. Upper Chanmari and Leary Colony, both will be South PS, okay? To take steps through the jurisdictional police station, okay? You serve.
Lordship, an interim order is there, your Lordship.
The interim order passed earlier shall continue till the next day, least after 3 weeks.
3 weeks, your Lordship. Grateful, deeply obliged.
That's all.